Hi, everybody. Nathan Semenska, thought leader for Wolters Kluwer ELM Solutions. As Sylvia said, we're going to be talking about inflation, how to combat it, legal spend management tools to navigate an uncertain economy. And our two guests are really excellent speakers, so I hope that you stick around for the whole presentation. Before we get into the meat and potatoes of the presentation, I want to share with you what I would call a PTSD story from my first job in legal operations. I was a business analyst embedded in a large corporation, about $156 billion in revenue, and I was helping with rate negotiations, and I was helping a practice group manager, and the law firm wanted, like 5%, and we were saying 3%. And so I produced all this data, and I showed different charts and things like that. But at the end of the day, basically there wasn't any patience for all this data and all this math and all this stuff. And the quote unquote analysis came down to, quote, it's only a 1% difference, or it's only a 2% difference. That was the level of analysis that went into this. And I just wanted to show you what the result of that type of thinking is in the long run. So we've got a theoretical situation here over a 20-year time horizon where everyone starts out at $100 an hour, but we've got 3 different clients, and one of them gives a 3% increase every year, one gives 4 and one gives 5. And after 20 years, the bottom one is $175 an hour, the middle is $211, and the other is $253. So that means the $211, the middle one, is paying 21% more, and the top one is paying 45% more. So if this is the way that you're doing stuff in your corporate law department, saying things like it's only a 1% difference, you're going to end up paying significantly more than peers in the long run. And it's really not being a good steward of corporate assets. You're going to have to be more rigorous than that in your analysis. So let's show the basic structure of the presentation today. We're going to have a very, very brief discussion of inflation, and then we will have 2 parts of actual analysis. One is ways to fight inflation that are not related to rates, and then ways to fight inflation which are related to rates. But before we get into that, I would like to ask our panelists to give an introduction of themselves. As I mentioned, I'm Nathan Semenska. I work for Wolters Kluwer. I am the Director of Legal Operations and Industry Insights over here. We are one of the biggest e-billing companies in the world. We also have a pretty cool contract lifecycle management product, a legal holds product, and an industry-leading artificial intelligence assisted invoice review product that crawls invoices and looks for charges that really don't need to be paid. But let's hear about our other guests. Bruce, do you want to start off?
Sure. I started Adam Smith Esquire 20 years ago. We're based in New York. We operate globally. It's a boutique management consultancy. I say boutique in that our clients are law firms and law firms only. We come at the industry from an economic standpoint. I was an economics undergrad in college. It changed my life. I was also a securities lawyer on Wall Street for about 20 years, both in big firms and in-house at Morgan Stanley. So I've been on the buy side, I've been on the sell side, and we just find, I just find the industry endlessly fascinating. It does say on the home site of on the home page of our website, adamsmithesk.com, that we do promise to our clients to tell them what we think. And I suspect at the conclusion of the hour, you will say that that is a true promise.
What about you, Ken?
Yeah, thanks, Nate. Ken Callender. I have my own consulting firm that I focus on mid to large size companies, helping them basically move off of hourly rates onto value-based fee arrangements and helping them overall with legal spend management, especially in the area of outside counsel. Prior to that, I was the head of legal operations at Uber. And prior to that, a CMO at a large international law firm. So I've seen both sides of the fence. And then prior to that, I was almost 30 years at Hewlett Packard running professional services for them. So it gives me a great background to do what I do, both on the pricing end and basically helping on overall legal spend management for clients.
Thank you, Ken. And now we are going to set stage for our discussion. We're not going to belabor the point, but we do want to give people a little bit of background about what inflation is. So I've heard the argument more than once in the last 6 months or so that inflation is 6% or it's 9%, therefore you need to give us X% increase, or we're going to have to grant this increase because of inflation. And I suspect that half the time the person that is making this argument could not even define what inflation is and is not aware that there are multiple methodologies for calculating inflation. And we're not going to go into all of these, but you can see here 5 of the most common methodologies. All of these are referred to fairly regularly in the media. And you can see based on the various methodologies, you could say that inflation is 4.6%. Or you could say it's 8.7%. So you can kind of pick your number and just, to bolster whatever argument it is that you want. The other thing about quote unquote inflation is, it's a roll up number of a basket of goods and services, which may not have anything to do with actual legal services. So here is a document or a graph from The Economist about a year ago. I would have better, more updated information, but this was the most recent thing I could find, and it's illustrative. It really doesn't matter whether this is the numbers that we would be seeing today, but you can see on the far right hand, car rental were up 110% year over year as of May 2021, and spectator sports were down about 5%. And the inflation number is basically this rolled up into a mean or median. So when somebody says that inflation is X%, that's not actually, doesn't actually correspond to anything in reality. The reality is these individual baskets of goods and services, and any particular basket of goods and services doesn't necessarily reflect quote unquote inflation. So when someone says, inflation it mandates that you give me this rate increase, is that a legitimate argument? And that's something that we're going to be going into, but we're going to do it in 2 parts: how to fight inflation in a non-rate related way, and then in a way that has to do with rates. So let's get into that. Let's talk about some of the best control tactics for reducing or at least mitigating cost increases. And this is data is a little bit old. It's a couple years old. It is from Altman Weil, which is a pretty distinguished legal consultancy out of Philadelphia, I believe. Unfortunately, they stopped issuing this report, but it was really one of the best reports that there were in the industry. And basically, the blue bar is the percentage of corporate law departments that have engaged in each of these various cost control measures in the year prior to the survey. And the green bar is the percentage of those folks that said basically that this works to help control costs. And so we've got, on the left, outsourcing to non-law firm vendors, shifting work in-house, enforcing budgets on major legal matters, alternative fee arrangements, and enforcing billing guidelines. So one of the things that I noticed when I put this together was the efficacy of these various tactics is sort of inversely proportional to how common they are. And Ken, you had a theory about why that might be. Now, just to be clear, all of these are pretty effective. I mean, if 75% of people say, yeah, this works, then it probably does work. But there's still this pattern that we're seeing. So Ken, what is the reason for that?
My thoughts when I saw this, Nate, is that the two on the left side, outsourcing the work and bringing work in-house, is very hard to do. It takes a lot of effort to do that. And if you're going to put that much effort into it, you want to make sure that you're going to get some positive results from it. When you start moving to the right, far over to the right of on the billing guidelines, that's pretty easy to do. I mean, it doesn't take a whole lot to enforce them. You can do it electronically. You can do it using third parties or both or in-house. And they still get, good savings out of that. As you can see from this, AFAs, the same thing. The issue I have on just calling it AFAs is that a lot of people have a different definition of what an AFA is. And so some people just think that getting a volume discount is an AFA. I really consider AFAs to be something where you're not involving any hourly rate management at all. But again, so that's a little bit harder to do. And as you can see, they sort of move down. And then enforcing budgets, again, some clients do that, some don't. Budgets are meant to be broken. When you make them, they're not a for sure thing. But again, the other two on the left are just hard to do.
Bruce, what's your reaction?
Yeah, thank you, Nate. And certainly I agree with everything you said, Ken. I think you and I share a pretty strict definition of AFAs, which is if they reflect billable time, they're not an AFA. But talking about this more from an economic perspective, I understand the data is 2 years old, Nate, but thank you for giving us the latest we have. It strikes me, looking at this as an economist more than as a lawyer, that the far left bar, outsourcing to non-law vendors, ALSPs, new law, whatever you want to call it, is a classic glaring example of market failure. Everybody seems to agree it's extremely effective and nobody's doing it. And, I could say, well, if you think it's effective and you're not doing it, it's your problem. But I want to look at this a little more objectively. I submit, with no data to show for it at the moment, but I think it'll emerge, that's changing, because that is such, as I said, a glaring example of market failure. The problem with new law right now, but this is what's changing, is there are 500, 800, 1,000, I don't know, point solutions in new law, right? There are all these little tiny firms. How many of them do e-discovery? How many of them do contract management? How many of them pretend to do, assisted document creation? But here's what's changing. The industry is beginning to consolidate, and there's beginning to be rationality and transparency into the industry. I cite as a primary example a new company called LexFusion, based here in New York. It didn't exist 2 years ago when this data was collected. LexFusion is an information clearinghouse. This is the sign of an industry gaining maturity. If you go to LexFusion, and they won't charge you, they charge new law, they don't charge clients. If you go to them and you say, what's the best contract management tool? They will tell you. They will make a recommendation. Now, you can ignore it. As I say, you haven't paid them anything. But their business is to keep close tabs on the market and figure these things out. So I submit, if Altman Weil came back to life and redid this next year, we'd see different results. I certainly hope we would.
Thanks. Yeah, I'm aware that that's like a Casey Flaherty's company and Paul Stroka. So those are definitely distinguished people in the profession, and they're very knowledgeable. I want to skip ahead a little bit since we seem to have gone into the ALSP thing. I want to share this data. This is from LegalView. This is our benchmarking database. It is the leading benchmark source for corporate law departments in the world. And this is actually showing a slight decline in ALSPs. You can see that the black is ALSP utilization, and the pink is the big four, and then you can see the blue is the combined. So they went down a little bit from 2016 to 2017. This is in our client base, and then they've basically been holding more or less flat. Now, I will say that this is in a context where in our client base, mean spend went up 36% from 2020 to 2021. So I am not trying to suggest that ALSPs are struggling or they're unable to compete. They actually had to have increased their revenue by about 36% in order to maintain the market share that they had. So this is not a story of ALSPs sputtering. This is a story of ALSPs keeping up more or less exactly with the rest of the market. The other thing that I want to point out about this is that this does not capture the situation where ALSPs partner with law firms and then the law firm white labels that and does not mention that an ALSP is basically a subcontractor to them in an individual legal matter. It also does not capture any situation where a captive ALSP is used. So, there's a number of these. I think there's like basically 100 at this point, captive ALSPs that are part of law firms. And I had our people go into our benchmarking database and look for the names of these captive ALSPs, and those names, out of like 100 names, 0 of them occurred in our benchmarking database. So there is more ALSP activity than what is reflected here, but I think it still is probably roughly proportional in terms of it going up or down. So that's why we're providing this information. But do either of you gentlemen want to add anything else to this discussion about ALSPs, or should we move on to AFAs and some of these other things?
I would just say, in addition, that because what Bruce just mentioned about the number of ALSPs out there, that they're under a lot of pricing pressure competitively. And so I don't see their pricing having gone up a whole lot, but the law firms have. So when you talk about that 36% or 33% increase in spend, that really skews it also, so that their share of that total spend shows to be flat. I think it shows that it's actually increasing significantly, probably more than that 33% or whatever you're talking about. So I think that it does show that this is really on an increase.
The other thing that I'll say is it's not out yet, but this research is from LegalView Volume 5. That is a series of thought leadership that I'm deeply involved in, and I've done a separate analysis that is just for the banking and finance industry, and I can't remember the number right now, but the percentage of ALSP spend in a banking and finance organization has gone up a ton in the last couple of years, just so people know, and that is a huge segment of the market. Bruce, do you have anything else to add to this, or should we move on to AFAs and some of this other stuff?
Just a quick footnote, and that's great new data, Nate. Thank you. Banking and finance are some of the most sophisticated legal buyers in the economy. ALSPs are also, and I'm going to state the obvious here, incredibly efficient compared to law firms. Our data shows 3, 4, 5, as much as 7 times multiple in what it costs to get a law firm to do something versus an ALSP. So they're doing a lot of work, even if it's not reflected in revenue.
Thank you. All right, let's talk about AFAs briefly. This is some data from this year from Legal Value Network, which is one of the leading thought leadership sources for pricing and legal project management. And basically what this says is that most law firms believe that their clients are not good at suggesting appropriate AFA types, and they're also not good at evaluating whatever options are on the table. it's also true that clients think that most law firms are not good at suggesting appropriate AFAs. So I myself am a firm believer in AFAs if they are done properly, but I do think that there is a lot of lazy thinking going on a lot of times where it's like AFA equals win, and that's like the analysis. So, you know, if you do a matter for a flat fee of $100,000 or you do it for a flat fee of $1 million, either way, you know, you save money because it was an AFA. We probably have to be a little more rigorous than that. And Ken, you don't like the term AFA. AFA is a component of your value-based pricing regime, which you sometimes use, but it's not the whole shebang. But certainly you must have a reaction to this.
Yeah, you know, I just work on the client side. I can understand why law firms probably don't think clients know what they're doing, but I can tell you that most of the AFA, quote unquote, AFAs we get from law firms are all tied to some sort of hours component. You know, their collars or their blended rates or the like. And, you know, and they consider those to be AFAs. And my clients really are, you know, they're needing some sort of predictability. And that still doesn't give you, you know, the predictability. They'll say, oh, it's you know, $100,000 with a 10% collar, right? All that means is that, you know, it's still hourly rates with a 10% buffer up or down, and it, you know, it's still based on hours. And so clients just, that's not what they need now. They need more predictability. They're being required by their finance teams to hold to a budget. They didn't used to be that, you know, that wasn't quite the component in the past because they used to get a pass from their CFOs, and now they're being held to their feet to the fire like all the other managers being held to a budget. And so predictability is really important. And what the law firms give us a lot of times is not predictable fees.
What about you, Bruce?
I would say if law firms aren't good at structuring AFAs or telling clients how it's going to work, it's their own fault because they have the data. They just don't mine it for what it's worth. You know, ask a law firm what it costs to defend a deposition, something very simple they do every day of the week. They can't tell you. They'll give you a range that, you know, that goes from 100 to 1,000.
But they've got the info, right?
They have the info. They're just not using it.
Yeah. Understood. All right. Let's see what else we've got here. Oh, I wanted to say one thing. My company does sell invoice review, and this isn't intended to be a salesy presentation, but I've got a little piece here about our product, which is called LegalView Bill Analyzer. Without going into detail, it uses artificial intelligence to look at invoices and find stuff that looks illegitimate, and then puts it in front of trained bill reviewers who then basically contact the law firm and negotiate with them. But that being said, you know, just the concept of bill review is something that is valuable according to the Altman-Weil survey that we saw, and most organizations have some kind of billing guidelines, but many of them do not actually enforce those guidelines as far as I can tell. Some of them do, some of them don't. And Ken, you have some rather pointed thoughts about what happens if you create billing guidelines and then do nothing beyond that.
Yeah, I mean, and I tell this to my clients, you know, if you have billing guidelines, first of all, make sure they're up to date and comprehensive. But if you don't enforce your billing guidelines, your firms aren't going to pay attention to them either. And you have to realize firms are getting billing guidelines from every one of their clients, and a lot of there's no standard, and so they're seeing all, and so they're not going to pay attention to what they are. And so if you're not paying attention to them and enforcing them, the firms won't either. You know, it's just like the old adage that, you know, people only pay attention to what you measure. So if you're not looking at them, they won't either. And so you've got to enforce them. And I often tell my clients, if you're going to have, you know, items in that billing guidelines that you're not going to enforce, you know, you might even consider not even putting them in there, because you know, unless it's really a significant issue that doesn't come up often, you know, if you're not going to pay attention to it, they won't either.
Yeah, I couldn't agree more. Bruce, do you have anything to add?
Ken said it all.
Fair enough. Okay, let's keep moving. And why can I not advance the slides? Here we go. Moving into part 2 of the presentation, ways to fight inflation that do have to do with rates. And I want to start off with a little quote from Milton Friedman, one of the most famous economists of all time. And he had this concept which he referred to as SEM, which means somebody else's money. And one of the quotes that he has about this is, nobody uses somebody else's resources as carefully as he or she uses their own. And so one of the examples, I watched a little YouTube video in preparation for this. One of his examples was, you're going out to dinner on the company credit card. So you're probably going to go to a little bit nicer restaurant than you would go if you were the one footing the bill. And when the check comes, you might be a little more generous with the tip, just because you're feeling, in a generous mood. And this is sometimes referred to as the principal agent problem in legal, actually. This, you run into this in legal, but also in economics, where, theoretically speaking, the interests of the representative and the interest of the person served are the same, but in reality, they're not always the same. So setting the stage, I do want to tell you a little bit about where the data that we're about to show you comes from. It comes from LegalView Data Warehouse. I already said, in our opinion, it is the leading source of performance benchmarking for corporate law departments in the world. It has $159 billion in spend and other associated data, which is all from clients of ours that have signed a contract to allow us to use their data for research and product development. We built it in 2010. We issued the first real rate report in 2011, which remains the #1 source of rate benchmarking data for corporate law departments and law firms. And today, this is more powerful than ever. We're onboarding new clients all the time. We're fixing, we're enhancing the data in various ways, and it does power a number of our solutions. Most of which have to do with rate benchmarking, but there's also the AI-assisted invoice review component that I described previously. The real rate report for 2022 is actually being formatted right now and should be out around October 1st. If you are a data contributor, it's free. If you are not, it's $500. You can just go into our website and buy it. Honestly, if you actually use it, this will be some of the best money that you ever spent. But let's look at a preliminary analysis of the data. This is something that I pulled together in the last couple of weeks, and you're hearing this argument from firms that, rates are going up, in our clients, or you're hearing the argument from our own clients saying, oh, I'm getting these the median rate increase request that I'm getting is 15%. So, maybe I won't grant that, but I'm going to have to give at least 10% or something. And in my opinion, this is basically benchmarking against gossip, because they're not looking at data like this. It hasn't been published yet. They're either looking at their own data or they're just talking to their peers. But the thing is, what our data shows is that 40% of timekeepers got zero. Okay. In fact, some of them went down. Now, to be clear, I highly doubt that the rates actually went down. This is the mean rate per each timekeeper. It's about 11,000 timekeepers. I think what's really happening here is they lost a very high paying client, or they gained a lower paying client. So it's not like they're cutting rates by 5 or 10% or something like that, right? But if you look at the numbers, the median increase is 1.86% and the mean is 5.6. Okay. And these are closer to the sort of thing you ought to be benchmarking against. Now, if you do look at the far right end of this, you will see about 8.7% of timekeepers got a rate increase of 20% or more. And, maybe the buyer could have done better in those negotiations, but maybe they couldn't have. And could we get a reaction from you, Bruce, being the economics guy in legal? You have a theory that there is basically a bifurcated market for legal. It's no longer a single market anymore. Is that true?
Absolutely, Nate. We developed this theory a couple of years ago, and it really it's every bit as strong as you say it is. It's not that law firms have segregated into two different sort of business models. We believe they've segregated into two different businesses. So the firms we call the Maroons, which are the elite, everybody could name 15 off the top of their heads, and 14 of them would be the same. Where money is no object, the EU sues Google for an antitrust violation. Money is no object. It's those firms that you go to for the $1,000 and up partners and boardroom visibility and boardroom reassurance. Everybody else, the vast majority of firms, I hate to say it, are what we call the grays, and they're for the routine, not bet the company, but run the company kind of business. And that's a really interesting business, right? I mean, Toyota Corolla is a really interesting product. It's not a BMW or an Audi, but I bet it's a lot more complex actually to build and design and do it efficiently, reliably, high quality all the time. So, but my point is there are, and this is your 8.7% over at the right, there are a number of firms where it really doesn't matter. There's also an economic truism in the background of all this. It's, the title of this morning's presentation has to do with inflation. I'm sure Milton Friedman would agree with it, but it's an economic truism that the best time to raise prices is when prices are rising, because people don't notice it so much. Eggs went up, well, milk went up, yeah, so big surprise. It's really a great time for law firms to raise rates.
Quickly, do you feel like in these rate negotiations, there are people who are grays, as you call them, who either think that they're Maroons, or at least, or in a Machiavellian way, they attempt to present themselves as Maroons in order to justify the increases that they are asking for? And what do you think the response should be from the buyer?
Well, to your question, are there grays who are aspirational, shall we say, about their status as Maroons? Absolutely. We had one managing partner react to this model by saying, well, actually, our firm is a rainbow firm. Okay, got it. But I think the answer to a gray that's aspirational about where they fit on the landscape from a client should be, that's great. Can you promise us Six Sigma reliability? In other words, I mean, going back to Toyota Corolla, I know it's a silly analogy perhaps, but it's at least detached from law land, so maybe we can be objective about it. You expect a Corolla to be an incredibly reliable car. You put the key in or carry the key fob nearby, and it starts, right? That's just what you're expecting. So the grays that can deliver incredibly reliable, high quality, no surprises work, they have a lot of running room. I actually think that's the most interesting model of all of these. It's more interesting than the Maroons. They just have to not screw it up. But to be what we call a superb gray is challenging, and clients will reward that. I guarantee you. They may not reward it with 10% rate increases every year, but they'll reward it with loyalty and increased share of wallet.
Thank you, Bruce. And Ken, what about you? What's your reaction to all this stuff?
Well, I love Bruce's analogies there, and I guess the Maserati doesn't start every time you don't expect it to start every time, but I totally agree with Bruce, and what I see on the client side is all the big firms, the ones he's talking about, the elite ones, they're all in that, and if you add this up here, everything 10% and above is probably about a quarter of the firms that are in that range. And we're certainly seeing that from the biggest firms. And again, The mid-sized firms don't have that pricing power. But the interesting thing that's, I think, and Bruce, I'd be interested to hear eventually or some other time your thoughts on this. What I see is the amount of that elite work is shrinking up there, and it's almost like, musical chairs. At some point, the music's going to stop, and these firms aren't, their work isn't going to be there because the grays are starting to eat, and the ALSPs too are starting to eat that commodity work up from the bottom, and the amount of that elite work is shrinking and shrinking. And I think, and everybody's going after it because that's where the big money is. And eventually, the chair is not going to be there when the music stops. And that's why I think you're starting to see a lot of mergers too in the space between law firms. And I don't know, Bruce, if you agree with that or not, but that's
no, I totally do. And the managing partner, now retired, of a firm that was squarely a maroon, once said to his partners, everybody's trying to get onto this little island, and it's a shrinking island.
Right.
The sea level is rising. So I totally agree with you. I'd also say on the flip side, Ken, that you're absolutely right that the grays are getting better and better. I mean, to go back to the Corolla analogy, today they have 10 or 12 airbags. They've had anti-lock brakes and electronic traction control forever. Lane change warnings, fabulous stereo systems, and all of this is in a $30,000 car. You used to have to pay $100 to get those things. So I agree with you. Everybody's moving up the food chain. The question for me, and we're doing a long range study of this, our firm has already launched it, is what is the coming collision between new law and the not superb grays going to look like? How is that going to play out?
Do you have any ideas on that, Ken? I think that, Ken, something that you said about ALSPs eating some of the lunch of the maroons is interesting, right? Because there's the question of, what rates maroons are getting paid, but then there's also the issue of unbundling. So maybe you can't say, hey, look, I'm not going to give you a 25% rate increase. Maybe you feel like you have to do that, but then out of the other side of your mouth, you can say, and I'm going to unbundle this and take away 30% of your hours and have it be done by, a 22-year-old kid who just graduated from Ohio State. What do you think?
Yeah, I mean, we've been seeing this, the ALSPs and these lower tier providers are starting to work their way. I mean, they were doing, doc review and stuff like that. They're now doing contract review. They're getting into immigration. They're getting into employment. They're sort of working their way up that value chain, and they're squeezing the firms to the upper end. And the grays, as Bruce calls them, they are fabulous firms. And a lot of the big law partners that don't like the big law, format are moving into these mid-level regional firms. So you're getting great work out of them. And when I talk to my clients, I tell them, break your work into like what I call the tier one work, which is that small island that Bruce is talking about, the strategic high impact stuff, and you just use your top firms for that. And then the run of the mill work, which is like that commodity level stuff that the grays are really good at, break it, that work only goes to them. And if you can just break that out in a process that breaks out the new work coming in as tier one or tier two and specifically route it to those firms, you'll save a lot of money just by doing that.
Agree. All right, let's keep moving. I want to just throw this out there because I found it to be shocking when I saw it. I annotate all of my PDFs, and when I saw this number, I typed into my annotation a word which is not shareable right now. but Ken was not surprised by this number. This again is from Altman Weil, and it's basically 79% of law firms say that at least 50% of their revenue comes from undiscounted rates. And I just thought that this was crazy because I thought that everyone got the memo that rack rates are not real, and that if you do not ask for a discount off of a rack rate, then you basically deserve to be put out to pasture. but in terms of the anatomy of a rate, right? I think most people on this call know this. But here's like a little sarcastic illustration about how you can get deeper and deeper discounts. And so we've got the same exact person, right? And their rack rate is different. And the rate that they ultimately settle on is the same in every situation. But the discount, it keeps going up and up until at the end, you've got these like really boss negotiators on the buy side. They're just nailing it and getting this 92% discount, which is incredible. I mean, can you think about like the negotiation genius that must be required in order to negotiate that kind of discount? And I've got a quote from someone whose name I will not mention, but is kind of a friend of me. And I compared this to the serial killer who in the movie who wants to be caught, so he or she leaves the breadcrumbs because they're just tired of the game. And I'll read it to you. The clients are the ones driving up the rack rate because they shop on discount. Most clients shop on discount. They don't shop on fee. And so in that dynamic, that's the market we have created, to where if clients are buying on discount, firms are actually foolish not to set their rack rates at a high level and have the ability to discount. Would either of you gentlemen like to comment on the absurdity of this concept?
Go ahead, Bruce. I'll let you start.
We're behaving like used car dealers or pawnbrokers, and I just find it borderline shameful. But to your friend's point, Nate, that's client behavior. What are you going to do?
Yeah, and I would add, your previous slide where almost 80% of the firms don't get discounts. I see that all the time. I have a client, which you mean rename the unnamed, who spends almost 400 million on outside counsel, and they don't use any discounts at all. And I told them, that's crazy. Everyone gets discounts, and they're afraid that if they ask for discounts, that the quality of the work is going to go down and they're not going to get the team that they want. And I tried to convince them and show them the data that, all the big companies and all the big firms give discounts and you should ask for them, and they just refuse to do it. So, which is just crazy. And I said, just getting a 10% discount from all your firms, that's a $40 million savings right there, right? And they just didn't get that. But, and getting back to the other slide, that's very true. They shop discounts because it's easy to manage and it's easy to see. And it's something that, is straightforward. And the rates, trying to compare rates, from practice to practice and region to region and jurisdiction to jurisdiction is just hard work. And it's just easier to just, when you're negotiating something, just say, oh, I just want, I want an 18% discount instead of 15, and that way they can say, well, we got better. But the firms know that, like you said, they know the game and they just raise the rates. And by the way, rack rates are really only a US firm phenomenon. If you go to Europe, the Magic Circles firms and all, they don't have quote unquote rack rates. Every client has their own rate, rack rate that they give them. And it's not like a standard rate practice. So that's just really a US thing.
I want to move on, but before I do that, I want to share another PTSD story, because I learned that in order to get PTSD, it may be from something you directly experienced, but there's actually something called secondary PTSD, where it happens to someone that you know, and then you get it too. So my friend, who is a pricing director at a big law firm, used to work for one of our clients, and he worked with procurement. I know we probably got a lot of procurement people on the call, and he was coming out of legal. He's a lawyer himself, and so he gets how the sausage is made. And he was basically saying, look, these discounts don't matter. They're not real. What we really need to do is do AFAs and things like that, because then there's going to be some predictability and relation, but just negotiating on the rate may have not a huge relationship to the ultimate cost that is paid. And the procurement person that he was talking to basically said, dude, you don't get it. Like, there's a system called iSave at my company, and I put in the discount that we negotiated, and then I get like $1,500. So I'm just gonna go ahead and put the number in there and get my bonus. So let's move on. Is there a danger of misaligned incentives, not just with procurement, but with all sorts of people in the legal space? If you look at the data, this is from my company. It's a few years old. Also, the sample size was not 1 million, I'll tell you that. But I do believe that it is directionally correct. And most folks on the buy side, which is our clients, agree that benchmarking is important. Rate benchmarking is important in some way. But you see it as they actually believe that benchmarking against their own rates is more important than benchmarking against peers, which I find to be perplexing because of the first slide in this presentation. You're basically, how do you know that you're not benchmarking against the equivalent of the water quality at Camp Lejeune? If you're just way out in left field, you are not necessarily benchmarking against a failure, potentially, if you don't know what you're doing and you're not looking at the context. And I wanted to share this slide as well. So this is who bought the real rate report over the last 5-6 years. And you can see it is, clients may think that benchmarking is important, but they don't all put their money where their mouth is. You can see that corporate buyers, maybe they're like 10 to 20% of the purchasers, and insurance is a little bit different. But by a wide margin, law firms are the people who actually put their money where their mouth is and buy this data and presumably use it. And my personal theory is this, that there are misaligned incentives. If I am a law firm partner and I get a 10 or 15% increase, then that's going to increase my draw, and I'm going to be able to buy that house in the south of France that I've been dreaming about, right? And if the GC or the legal ops person or whoever knocks that rate increase down to 10% or 5% or whatever the number is, they basically get a pat on the back. Do either of you folks think that this is a sort of a risk that not only, the other thing is, not only are there misaligned incentives, but in the long run, the misaligned incentives cause the corporate law department to get further and further behind because they don't make the investment in people, process, and technology. They don't upgrade their rate management process. And so every year, the law firm gets better and better at these negotiations, whereas the buy is basically just treading water. What do you two think?
I just think it's a principal agent problem. Again, the partner has a self-interest in this data, so they're buying it. Look at that. I mean, it's just shocking, the disproportion between law firms and corporate buyers. And the corporations are, again, I could blame them, but they're behaving rationally. It is not their money. Ken?
Yeah, and I agree there. It is, the law firms are very interested in this data, and they're very competitive, and they're comparing themselves against their peers. On the corporate side, you got to remember, corporate teams run really lean. They don't have a lot of time to do a lot of data analysis, to try and compare again all this data for other companies are doing, and by practice area, by region, by jurisdiction, is a lot of work. Plus, you got to realize that they're all working against a budget, and they have and it usually is looking at the prior year's budget, which is why I totally see why they're looking at the numbers of their own numbers versus peers, because their budget has to, they have to drop it by 5%, or they're going to get a 3% increase in their budget, whatever. And so they have to measure that against their previous numbers. And so that's why they're looking at their numbers and not looking at peers. It's easier to do. They have that number. It's not a lot of work for them, or not as much work as to try and do it against other numbers outside.
Thank you both. Okay, we are getting close to the end of the presentation, but I wanted to go into some of these sort of blocking and tackling ways to try to save money. Maybe not immediately, but in some cases in the long run. So the first one is what I call minimum viable vendor policies. We have a big client that's pretty sophisticated. They reduced their legal spend by 30–40% in 3 years. And the main thing that they say helped them do that was they created a series of rebuttable presumptions. When a new legal matter occurs, the presumption is that this will be insourced. And if you don't want to insource it, or you can't, that's fine, but you actually need to go into a web page and then put the reason why you can't insource this. And then the next presumption is that you use the lowest tier of firm or an ALSP. And then if you can't or won't do that, then you need to put in a reason, and then you rebut that presumption. So you have to go through like 3, 4, 5 levels to go and hire Latham or whoever it is. And the whole idea was that people were jumping the gun, and hiring, Uber firms for things that were relatively mundane. Ken, I think you've seen some of this behavior. Do you have any comments on this?
Yeah, this is what I call a matter intake process, right? And when new matters come in, making sure that, is it really a legal matter? If it is, has it been approved by management, especially if it came out of a business unit, then deciding whether or not this is going to be done inside or go outside. If it does go inside, who does it go to? If it goes outside, just like you were saying, deciding who it goes to tied to the matter value of the matter, and making sure that you have a set of firms, your premier firms or your second tier firms, and just making sure that it's going in the right direction and pushing that work down, or using an ALSP or contract attorneys or whatever. But having just a matter intake process that you go through step by step for every new matter that comes in really can help you in that process. So it's totally right.
All right. Bruce, I'd like to give you a chance to comment on this. There's some other things on the screen I'd like to talk about, but we've only got 5 minutes. So Bruce, if you've got something to say, fire. Otherwise, let's open up for comment.
I think we can open this up for comments. I mean, Ken captured it all. When I was in-house at Morgan Stanley hiring law firms like those in the audience, I had an internal compass or gyroscope about what a matter was worth, but maybe that's just because I'm Scottish and I'm cheap.
They do have that reputation, don't they? But if it's not Scottish, it's crop. So okay. Any questions or comments? Do our audience members have anything that they would like to say? If not, we've got a couple other things that we could talk about.
So I just found out that some people have the chat disabled for some reason. As I just wrote in the chat box, because my chat works. So if you would like to ask a question, but it does show chat disabled, please just raise your hand and then we can unmute you. And then you can ask a question. So again, there is one. Okay, hold on. Jessica, you were the first one. This is Jessica Williams. You have the word, Jessica.
Thank you so much. First off, great presentation, guys. This is very, very helpful, as I am going into rate review literally almost as we speak. So really great data. I do have one question about the 40% of timekeepers that aren't getting rate increases slide that you had. 2 things. One, are you factoring in timekeepers that are under the 2-year rate freeze? So are these, I guess my question here is, in the underlying data, are we looking at only those that made requests, or are we looking at all of the timekeepers across the spend?
Yeah, good question. It's anybody. So whether or not they made a request. So some of them, I guess they just don't like money, and so they didn't ask for more. but other ones asked for more and were told no, or just never got an answer back, basically.
Great. So the second follow-up question that I have to that then is, this is what I commonly say. I will get a rate request increase from one of my firms, I'll have 50 some odd timekeepers that come through, and only about 5 or 6 of them have ever billed me any time. They will say this is a 5% increase.
Yes.
But when you remove all those non-billing timekeepers, it's really a 35% increase. So
yes,
I guess that's my other question when it comes to the data is, how is that calculated in there, or is it?
So the idea is that this is a brand new timekeeper that you have no experience with before, and so it's neither an increase nor a decrease. It's just the number that the first time you've seen this person. Is that your question?
No, not necessarily the first time I've seen this person, but somebody that they've put in throughout the year, right? But has never billed me. They're never going to bill me. They're using it basically as a, you know, they'll put in for a 0% increase, right? And it'll bring the overall average increase that the firm is requesting down.
Yes.
And so the argument is made.
So you're talking about, they're basically saying the increase is blended. You should go based off of a blended number.
Precisely.
And you okay. So yes. So the answer to your question is this is not blended data. Okay. It is timekeeper by timekeeper, right? That is how we were able to arrive at the numbers that we looked at. You know, like I said, the real rate report will be out on about October 1st. And one of the things now the real rate report itself is blended because it's not meant for you to calculate what rate increases are. It's meant to see the blended rate for various permutations of timekeeper, and there's literally, I mean, it's 240 pages long, so it's a
yeah,
pretty much pretty much any permutation you could think of, right? But it's you're very smart to ask this question because we actually saw some categories of timekeeper blended rate go down from 2021 to 2022, and the reason for that is at least partially because of senior people retiring, or perhaps going in house or doing something like that, whereas younger, you know, people who charge less going into the profession. But the other thing is, we particularly saw this in paralegals. Paralegals, commonly their blended rate went down from 2021 to 2022, and I think I don't know, but I suspect that there were a lot of senior paralegals who, you know, the pandemic happened and they were basically like ready to retire, and then they're like, oh, the pandemic, it's uncertainty, I guess I'll just hang in there for a couple more years, and then, you know, the world didn't end. And then they retired, right? So I think that is a lot of what's going on. But yeah, to answer your question, the slide that I showed is not blended rates; it's timekeeper by timekeeper, and the rate, how much the rate went up for each of those. And the real rate report doesn't really talk about that, but there is going to be another report issued in November, which is called LegalView Volume 6. It's basically my job, and it's going to involve an extensive analysis of how much rates are going up in all sorts of different slices by AMLA tier, blah, blah, blah.